Question is that the bill be now read a second time. Mr. Zhulkarnain.
Mr. Speaker, sir, I declare my interest as a practicing lawyer. I stand in support of the bills and the restructuring of our legal service into separate Judicial Service Commission and the Legal Service Commission. In July, my fellow members from the Law GPC, Mr. Murali Pillay, Mr. Lim Biao Chuan, and Mr. Christopher D'Souza had spoken about the need to consider whether it would be feasible to set up a separate Judicial Service Commission that would be in a better position to nurture specialist judicial officers. The government in response has stated that it will consider and study the proposals, and so I'm glad that these bills have now come to be tabled before this House. The integrated model of our legal service, where officers are deployed to both judicial and legal branches, has previously met our manpower needs and helped us to build up our dispute resolution hub and status as a well-respected judiciary in the world. This is no mean feat, particularly given our small population and limited talent pool. We have heard from Minister about the great work that our legal service officers have done, especially to meet our COVID-19 pandemic challenges as well. But as Singapore adds to its repertoire of being the preferred international dispute hub, we need to ensure that our judiciary and legal service are also well equipped to meet any new challenges ahead. In the midst of fast-paced disruptions to our legal environment and profession, we are also facing a real competition with other emerging and lucrative sectors to train and retain the talent pool both in our Singapore Bar, the legal service, and our bench. In preparation to meet future challenges caused by these changes, we need to build a strong and deep bench towards specialization of emerging areas of law and expertise required in the future. However, we also need to ensure good range of exposure, especially for our younger officers. In this regard, younger doesn't mean in terms of age, but for those less experienced. I do have some clarifications that I would like to cover in three parts. Firstly, the career in the courts. Secondly, the challenges in the future. And the last part is the expertise in community niche and culturally sensitive areas, which I will deliver in Malay. The first part, career in the courts. In relation to Clause 26 of the bill, which is the transitional provision, existing officers in the legal service will be allocated or redeployed according to the posts that they are holding. For example, existing office holders in the Supreme Courts or other subordinate courts like the Family Justice Courts shall come under the newly formed Judicial Service Commission. A judicial branch officer is defined as an existing officer who is holding a post in the Supreme Court or a subordinate court. My question is, what would be the definition of a subordinate court? Besides the Family Justice Court and the state courts, what others can be taken into consideration? Example, tribunals. We are also facing the challenge of a limited talent pool. Now, recently, 3 judicial commissioners have been appointed judges in the Supreme Court. They are either senior counsel or senior practitioners taken from the bar, one of whom I appeared before. He was my arbitrator, another was an opposing counsel, the third I worked with. As much as I'm glad that we have very talented and esteemed appointments to the judiciary bench, the thinning of the talent at the bar is a very real risk to our legal profession. We need to ensure that the deep bench in our courts does not come at the expense of the bar and deplete our talent pool at the Singapore Bar, which is detrimental to our status of our dispute resolution hub. Hence, the talent for our judiciary and the bench must be built up internally as well. I would propose that despite the separate arms being set up with the LSC and the JSC, that there should still be some flexibility or a fixed rotation between JSC and LSC officers in the early years of their career. This is so that they can also get sufficient experience and also be exposed to experience in other courts. Hence, I would like to ask whether there would be flexibility to allow for transfers between both commissions to better prepare ourselves for the future needs of the bench. Speaking about the future needs of the bench, this flows into the second part of my speech on challenges in the future. Now, the future challenges of greater cross-border litigation, which not only involve complex legal or factual issues, also inevitably involves issues of conflict of laws and interface between common law and civil law systems in the various legal systems in other countries. New and specialized areas of law, for example, those involving smart contracts and cryptocurrency, would also require our judges to be equipped with the necessary commercial and perhaps private practice experience and practical know-how. This would greatly complement the technical and legal skills already on the bench. Ultimately, a strong bench would help to attract more disputes and bolster our dispute resolution hub status as a nation. We thus need judges who understand practice and commercial realities. Thus, without risk of thinning the bar, perhaps the ministry could look into the secondment of judicial service officers in specific private practice areas or international postings in the early parts of their career. Now, of course, this is subject to issues of conflict of interest in the future and disclosure of associations in the future once that officer leaves private practice to rejoin the judiciary. However, such declarations are already the norm now when judges declare any potential conflict of interest prior to being docketed as a judge for a case. Now, already we have seen in the courts how a docket system of specialist judges with the relevant practice experience and managing the case from the outset would improve the case management, and our cases in litigation have now progressed efficiently and effectively. Perhaps also to complement the skill set, we can have more invited international judges to be part of our judiciary and not just for cases before the SICC or the Singapore International Commercial Courts, but perhaps the IJs or international judges can also sit in specific high court cases or appeals whenever necessary. We not only have to broaden our talent pool to meet future challenges, we would also have to deepen our expertise in certain niche areas where perhaps there would be some religious or cultural sensitivities. Now, in this regard, Mr. Speaker, I will move on to the last part of my speech, which I will deliver in Malay. Now, the third part, community, cultural, religious sensitivities. Untuk menarik dana antarabangsa atau individu yang mempunyai aset yang bernilai tinggi, iaitu high net worth individuals, untuk menubuhkan wakaf atau melabur di Singapura, kita harus memperkukuhkan lagi status Singapura sebagai hub penyelesaian pertikaian terkemuka. Selain daripada itu, sektor kewangan Islam telah melihat kenaikan kes yang dikemukakan di mahkamah dan proses timbang tara di serata dunia, termasuk institusi di kawasan Malaysia dan Timur Tengah. Kes-kes ini memerlukan kepakaran yang mendalam dan rangka kerja undang-undang yang menyeluruh bagi mengendalikan kes-kes pertikaian kewangan Islam. Ia juga memerlukan pendekatan yang berhemah dan sensitif mengikut wilayah tertentu. Selain daripada kes-kes komersial atau civil, mahkamah kita juga menghadapi kes-kes yang melibatkan isu-isu sensitif yang menjejas semua lapisan masyarakat Islam kita. Ini termasuk tafsiran isu-isu undang syariah seperti tafsiran undang-undang pentadbiran, undang-undang Islam iaitu amlah, wakaf atau undang-undang pusaka Islam, faraid. dan undang-undang perkahwinan dan pewarisan orang Islam yang kadangkala dibicarakan di Mahkamah Tinggi. Dalam ucapan sulung saya di Parlimen, saya telah menyarankan bagaimana proses timbang tara atau rangka perundangan yang lebih menyeluruh dapat dikaji untuk menangani kes-kes pertikaian wakaf atau harta pusaka masyarakat kita. Ini boleh dilakukan melalui perluasan bidang kuasa mahkamah syariah atau mendalamkan lagi pengkhususan mahkamah sivil kita untuk mengendalikan kes-kes seperti ini. Semua isu-isu ini memberi kesan kepada masyarakat Islam kita. Di sini, perlembagaan negara kita mengiktiraf kedudukan istimewa orang Melayu dan melakarkan komitmen pemerintah untuk menitik beratkan kepentingan masyarakat Melayu Islam dan bahasa Melayu kita. Dari segi undang-undang pula, undang-undang Islam adalah sebahagian daripada undang-undang negara kita. Justru, mahkamah sivil kita mempunyai kuasa untuk mentafsir undang-undang itu sendiri. Oleh itu, mahkamah sivil apabila berhadapan dengan persoalan undang-undang Islam tidak diwajibkan untuk mendapatkan pendapat daripada MUIS. Oleh itu, saya fikir tepat masanya pemerintah menubuhkan Suruhanjaya Perkhidmatan Kehakiman iaitu Judicial Service Commission atau JSC. Ia bukan sahaja dapat memberi pengkhususan yang diperlukan tetapi juga dapat mengimbangi pendekatan yang perlu diambil dalam menangani kes-kes tertentu. Saranan saya adalah untuk ahli JSC yang sesuai supaya turut dipinjamkan atau bergilir mengendalikan kes mahkamah syariah atau lembaga rayuan syariah untuk membina pemahaman dan pengetahuan mereka. Saya difahamkan bahawa ini sudah pun berlaku dan mungkin landasan kerja dan perkembangan pegawai JSC yang dipinjamkan boleh dijelaskan lagi supaya giliran jawatan ini dapat menarik lebih ramai pegawai JSC. Saya juga mencadangkan agar diwujudkan perkongsian silang dan pembelajaran antara mahkamah termasuk pegawai mahkamah syariah dan mahkamah sivil dan semua latihan mungkin boleh dapat dikendalikan di bawah naungan Kolej Kehakiman Singapura. Akhir sekali, saya mengalu-alukan pembangunan Suruhanjaya ini yang dapat memenuhi keperluan masyarakat dan menangani cabaran kes-kes yang lebih rumit di masa depan untuk negara kita. Mr. Speaker, sir, I support the bills.